nuisance, they have to exclude a normal agricultural operation from that definition. It also limits neighbors from filing a nuisance lawsuit against the farm, and then it also provides some protections for farms that are doing some direct sales. So municipalities have some limitations on their ability to restrict those on-site direct sales. I'll talk about the neighbor nuisance protection. And a neighbor is not going to be able to successfully pursue a nuisance lawsuit against a farm if the operation has been lawfully existing for 1 year and the conditions that the neighbor is complaining of have been in existence for 1 year, and those conditions are normal agricultural operations. So if a neighbor is complaining about odors from a livestock facility, and those conditions have been present for more than a year, then that neighbor is not going to be able to pursue a nuisance lawsuit. So that provides some protection for the farms, but there still is that 1 year window that the neighbors can file a suit. In 1998, the amendment to the right to farm law addressed the expansion. And if you think of that 1 year window, if you're thinking about expanding your operation, you're going to want to incur significant expense and have your neighbors have 1 year that they can file a suit. And it's not a good position to be in. So the legislature provided a way to reduce that 1 year time period. So for a farm that is expanding or changing the use, if they file a nutrient management plan, then that 1 year time period is eliminated. So that's important if you're thinking of expanding, or if a farm is thinking of expanding. You need to think about whether, even if you're not required to file that, it might be advantageous to do that in order to prevent neighbors from filing a nuisance lawsuit. The right to farm law, there was a thought that it didn't go far enough. It just addressed the nuisance. It didn't provide for remedies for violations. It required farmers to bear the costs of enforcing that issues, or this specifically with regard to municipal ordinances. If a farmer was going to challenge that, they were going to have to bear the cost. And there was one instance in Bradford County that was kind of pointed at as reflecting the problems with the right to farm law as it related to municipal regulation, where a dairy farm was looking to expand and build a hog facility, and the township imposed setback requirements that were in conflict with the state law. And those setback requirements essentially were preventing that hog facility from being located anywhere on that property. So the farmers filed suit and ultimately got that ordinance struck down, but they had to incur significant expense in doing so. So the thought was the right to farm law didn't provide enough protection, and so ACRE was enacted in 2005. And the basic premise of ACRE as it relates to municipal ordinances is that a local government unit shall not adopt or enforce an unauthorized local ordinance. So if a municipality acts in a way that is in conflict with state law, then the landowner, the farmer, they can request the Attorney General review that ordinance. And if the Attorney General thinks that the municipality has acted in conflict with state law, then the Attorney General is authorized to file a suit. It protects normal agricultural operations, so that's a fairly broad definition, but it encompasses the production, a lot of different aspects of agriculture and a wide variety of different agricultural enterprises. Okay, so the procedure, when a request is made to the Attorney General and they have 120 days, they will try to negotiate for a resolution if they believe that the ordinance violates state law, but if they can't resolve that, then they will file suit in Commonwealth Court. Okay, the third law that I'll just briefly talk about is the Ag Area Security Law. And the fundamental part of this law is the creation of ag security areas. When land is within an ag security area, it's entitled to certain protections. There are limitations on the local regulations that somewhat mirror the right to farm law, but also are something slightly different. There's a limitation on the power of eminent domain, where if the government is going to utilize eminent domain, they have to go through the Agricultural Lands Condemnation Approval Board and demonstrate that there's no other alternative but to take that land. And then landowners, the third benefit of being in an ag security area is they can participate in the state's purchase of ag conservation easement program. I'll just skip. And the fourth statute that I just wanted to briefly talk on, because I'm probably just about out of time, is the Clean and Green program. And you might not initially think of this as being a program that addresses that conflict between farming and development, but it is, because as a result of having development in close proximity to farmland, taxes can be much higher on that farmland, and that can be a pressure on farmers that maybe they aren't able to pay those taxes, or it pushes them to possibly get out of farming because of that burden. So this is a state statute, but it's administered at the county level. Just about all the counties in the state have it, and it provides preferential tax assessment to eligible ag land, ag reserve, or forest reserve. And the taxes are assessed based on the use value rather than the fair market value. So it's taxed based on, if it's agricultural land, it's taxed based on its agricultural value, not on whatever the fair market value of that land would be. And there was some discussion about the size. For agricultural land, it's a 10-acre in size or a $2,000 gross annual income threshold. And I've actually heard more discussion about raising that $2,000 threshold than the acreage size. But it's one or the other. If you have either 10 acres or you have annual gross income of $2,000, you can qualify for agricultural use under the program. Agricultural reserve is a 10-acre minimum, and that land has to be open to the public. And that's what a lot of people don't realize, that you see a lot of 10-acre lots that are in Clean and Green, and they don't realize that if you're in ag reserve, that land has to be open to the public. And there was a reporter from Pittsburgh, one of the Pittsburgh TV stations, did a series where he would go out and have picnics on people's yards or drive golf balls, and just to try to see what their reaction was, because a lot of people didn't realize that there was a requirement for public use in the agricultural reserve program. Not the agricultural use, but for agricultural reserve. So that's just a real brief run through of what I think are the four major state statutes that address that issue of agriculture and commercial and residential development encroaching on each other. We didn't really talk about zoning. That's something we'll talk about later in a few months when we